5 seconds to go. Start. The principles with regard to awarding punishment of death are now well settled by judgments of this court in Bachan Singh versus State of Punjab. Briefly stated, the principles are that on conviction under section 302 IPC, the normal rule is to award punishment of life imprisonment, and that the punishment of death should be reserved only for the rarest of rare cases. Whether a case falls within the rarest of rare cases has to be examined with reference to the facts and circumstances of each case. The court has to take note of the aggravating as well as the mitigating circumstances and conclude whether there was something uncommon about the crime which renders the sentence of imprisonment for life inadequate and calls for a death sentence. The court is also expected to consider whether the circumstances of the crime is such that there is no alternative but to impose death sentence after according maximum weightage to the mitigating circumstances which speak in favor of the offender. These principles have been applied by this court in innumerable cases. The learned counsel for the appellant has, however, relied on the judgment of this court in Raja Ram Yadav and others versus State of Bihar 1996 9 SCC 287 in support of his contention that the death sentence has to be commuted into life imprisonment. In that case, the convicts appellants were tried for offence punishable under section 302 IPC and were sentenced to death by the trial court. There were feuds between Rajputs and Yadavs in Chechanai. The incident of carnage to which the case related had taken place as the retaliation of Yadavs by killing the Rajputs. The trial court awarded death sentence which was confirmed by the High Court. The sole eyewitness of the occurrence was 9-year-old boy. While reiterating the aforesaid principles, this court on the special facts of the case held thus: after keeping in mind the relevant considerations for awarding the extreme penalty of death and also on considering the fact that in the instance case the sole eyewitness did not tell, according to PW1, the names of 4 of the appellants, we feel that although the murders had been committed in a premeditated and calculated manner with extreme cruelty and brutality, for which normally sentence of death will be wholly justified in the special facts of the case, it will not be proper to award extreme sentence of death on the appellants. The other case referred to by him is Roni versus State of Maharashtra 1998 3 SCC 625. There, 3 appellants were convicted under sections 376 and 302 and 34 IPC for committing rape and gruesome murder and were sentenced to death by the trial court. The High Court declined to take a different view. This court, while considering the question of sentence, observed that as it was not possible to predict as to who among the 3 played which part, and therefore it might be that the role of one had been more culpable in degree than that of the others, and vice versa, and considered it appropriate to commute the death sentence to imprisonment for life. In State of Himachal Pradesh versus Manohar Singh Thakur 1998 6 SCC 158, the evidence against the convict was circumstantial evidence. The trial court convicted him of offence punishable under section 302, but the High Court on appeal recorded acquittal. On the state's appeal to this court, the judgment of the High Court was set aside and the order of conviction passed by the trial court was restored. On the question of sentence, it was observed that though Murder, by its very nature, is shocking, that per se does not justify death penalty. Further, this court found that it was not a rarest of rare case. This court laid down that unless the nature of the crime and the circumstances of the offender reveal that the criminal is a menace to the society, and the sentence of life imprisonment would be altogether inadequate, the court should ordinarily impose the lesser punishment and not the extreme punishment of death, which should be reserved for exceptional cases only. The ratio of these cases is of no help to the appellant. We may, however, note here that in Shankar vs. State of Tamil Nadu 1994 for SCC 478, the finding recorded by the High Court was that the crime indulged was gruesome, cold-blooded, heinous, atrocious, and cruel, and the accused appellant was proved to be an ardent criminal and thus a menace to the society. On those findings, the death sentence was confirmed by this court, as the facts disclosed that the culpability of the accused appellant has assumed extreme depravity, and therefore special reasons can be said to exist to order the death penalty. Stop.